What is my default estate plan, and who wrote it for me? Hi, I'm Gary DeWitt from the DeWitt Law Firm. We do estate planning, we do probate, and we do them well. If you have questions about this or anything else, you can set up a time to talk to me for free over the phone or in person by going to planwithgary.com. Everybody over the age of 18 has an estate plan. They either wrote it or the legislature wrote it for them. How do you feel about the senators and congresspeople down in the state capitol writing your plan for you? If you like the thought of politicians writing your plan and deciding what's in your best interest, then don't do anything. If you want to maximize the taxes you'll have to pay, don't do anything. If you want to maximize the hassles for your family, don't do anything. If you want to maximize expenses for your family, don't do anything. If you don't create your own plan, the state has written one for you. Their plan takes the intervention of a judge and the oversight of the courts. Most people don't want their family's business and affairs controlled by a judge or exposed to the public. The state's plan is roughly divided into distribution of your final estate and control of your lifetime affairs. The state has a plan for managing your lifetime decisions and a plan for the distribution of your final estate. And just like cooking, there are cooks who improvise and cooks who follow the recipes. The state's plan for distribution follows the recipe strictly. Your plan can improvise the recipe and adjust the ingredients to your own taste. If the state has a plan already written for you, then what's all the fuss about doing your own plan? Probate. Probate can take 8 months to years to finish. Probate is public. Guardianships rip away your rights to manage your affairs and give the control of your affairs to a judge. Guardianships make your family's affairs private or private affairs public. You can't disinherit a child under the state's plan. The state's plan just hands out lump sums of money to people over 18. And there's much more. Mark didn't think writing his plan was important, so he just never did it. As he aged, his mental capacity began to diminish. He started having trouble paying the bills, banking, and maintaining and doing other affairs of daily living, so he asked his daughter to help. When they went to the attorney to draw up a plan, the attorney refused. He said that Mark was already beyond the point where he could sign a power of attorney. So the daughter had to go to court and get a guardianship, and that cost $2,500 in fees and cost. If any of her siblings had fought it, it would have cost much more. If Mark had written a plan years before, it would have cost much less. Mark's daughter had to publish an annual inventory of Mark's accounting and what he owned. His inventory and accounting became part of the public record. And then when Mark's daughter needed to sell the house to take care of him, she had to go back to court to get permission to sell the house. The judge required 3 appraisals at a cost of over $1,500 before allowing sale of the property. And then Mark's daughter had to report the sale back to the court and the terms of the sale, so it became part of the public record too. So if you can't manage your own affairs because of mental decline, the state's plan is called guardianship. The state's plan says what happens when your mental capacity diminishes or you can't resist outside influence anymore. When others are taking advantage of you because of your mental decline, then somebody has to go to court and get permission to become your guardian. Most, if not all states, have written a default estate plan for people that choose not to write their own for the distribution of their final estate. It's not just a plan, it's written in legalese and it differs from state to state. Most people I know aren't satisfied with the state's plan. Not only does it have laws in place for how your life is managed if you can't manage it, it tells your family how your final estate is to be divided and when it is distributed. The cost of distribution will run 6% or more of your final estate, and that's your gross estate. That is, not taking out any loans or mortgages against the property. So even though Mark wanted his daughter to have a bigger share of the estate because she helped take care of him, under state law, that didn't happen. If you have questions about this or anything else, you can set up a time to talk to me for free over the phone or in person by going to planwithgary.com.